Rub-a-dub-dub. We're getting started, ladies and gentlemen. Hear me out there. What we're doing. Ladies and gentlemen, it is Saturday morning here in Mississippi. Afternoon, other places in the world. We're getting started here from the gallery for our end of week case review. And we've got a lot to get through today, ladies and gentlemen. We're starting the week off at the beginning of the week with Judge McNally and a feud between brothers that couldn't be worse. Just want to point out the puppies over here, ladies and gentlemen. You don't get any better than that. After Judge McNally, we're going to Judge Simpson for a defendant who thinks he can work quid pro quo with testimony, and man, that's not going to go the way he hopes it will. Then we're going to go to Cowlitz County, where Judge Sanders is still dealing with some commercial traffic issues. She's going to see if she can get that taken care of today, and we're going to end things with Judge Shackelford, ladies and gentlemen, and Judge Shackelford has a big mess in Taylor, and we're going to see all there is to see. I got things tied together so every story is told just so back to back with Judge Shackelford. Those are some in-custody matters, but first, we're going to deal with these brothers in Judge McNally's. That was on the 16th. Judge Simpson is the 17th. Cowlitz is on the 18th. We're skipping the 19th, ladies and gentlemen, because you know there wasn't much going on that day. And we're ending with Shackelford yesterday on the 20th. So that's our Friday docket. That's what we got set up for today. That's what I got planned. It's a full 2 hours. I hope you enjoy it. I'm ready to get it started. We're going to let the music play for a few minutes, and we're going to let the video get started. Ladies and gentlemen, thank you for coming out. Barry, that first track was just for you. Myco Psycho, good seeing you. Allison, good seeing you. Your mom's out there someplace. Pitbull Mama, I'm glad to see you. Tev, good to see you. RD Fox, good to see you. And Rhonda, of course, good to see you. Welcome, early birds, one and all. I got to scroll through this to see what's going on. Hey, you know what's going on right now. Ladies and gentlemen, I am your Lone Wolf Usul. I am your curator for these here videos, and I am your host here from the gallery. We're going to get things started in just a few seconds. Blah, blah, blah. Again, puppies. puppies. What more can you say?
Donald versus Ronald Pittaway. 2502023. Who's Donald? Who's Ronald? Come on up here.
We're both Donald.
Your name, sir?
He's Donald Pittaway Senior. I'm Donald Pittaway Junior.
Well, who's the plaintiff? I can't even tell.
Me, but my father was the homeowner and stuff, and we had a discussion about that last time we were here in court.
Wait a minute. Who filed the claim?
I did.
You can't do that. Didn't I tell you that? Did I not tell you that?
Tell me.
Did I not tell you that?
Yeah, you said something about, well, you're not the homeowner.
Well, and so I adjourned it. You got to get a lawyer to handle this for you,
Well,
sir.
I did.
It's not for you, it's for him.
I did wind up contacting an attorney. I don't have I can't meet with him until June 30th.
Your name?
Ronald Pittaway.
Who owns this home? You own this home? Yes? I can't hear you.
Yes,
And you're Donald Pittaway Senior, right?
yes.
And where's the property? On Maple Lane?
No, 20679 on Churchill Avenue.
Why is-
The Maple Lane is where he lives.
That's not where I live, my address is.
The property that we're talking about here, is it for Churchill Avenue? Is it for?
Yes.
Yes,
Yes.
that's where we live, Churchill.
Do you live there?
That's my residence, yes. It's on my driver's license. I live there, my property's there. He tried to take it.
Hang on a second.
They locked the doors on me and changed.
Time out. Time out. You're his son? Are you his son?
Yes,
Oh, this isn't very fun.
Exactly.
Who else lives at that Churchill address? Do you live there, Don Pittaway Senior?
Yes, I do.
Do you live there, Don Pittaway Junior?
Correct.
And so does Ronald?
And he moved his stuff to the Maple Lane address, and he's trying to get away with living at two addresses when I'm trying to evict him. What's basically gonna happen?
Hang on. You are not trying to do anything because you're not the plaintiff. What do you mean, whatever? Mr.
My father's 85 years old, sir.
I get it.
84.
I don't think he's being disrespectful, but I can't just say whatever. I have to have the real party and interest starting the action. That being said, Ronald, come on. What was yesterday again?
June 15th,
Yeah, I know. What else was it?
Father's Day, I was there.
I know.
He pulled the
Stop.
gun on that.
I didn't ask you that. It's Father's Day,
Father's Day.
right?
Yeah, I just stopped him starting to fight yesterday.
Stop.
All my brothers were there.
Listen to me. How many dads you got? That's what I want you to answer. How many fathers you got?
One,
Okay. Yesterday was Father's Day. What a sad commentary that an 85-year-old, and how old are you?
he's 84. I'm just being accurate, sir.
All right. How old are you?
853.
My dad. See that guy in the wall?
I know Gerald.
Huh?
Gerald McNally?
Who's my dad?
Yeah.
53 when he died. How old are you?
56.
You guys are carrying on like that in this world that's so short, this silly, ridiculous, and I've got a lot of other words I could call it, but they wouldn't be appropriate. Now, why aren't you just vacating the house without putting people through all this
It's only
nonsense?
about 30 grand.
I did not finish asking my question.
Sorry, sir.
You keep interrupting me. Why aren't you just moving out of the house? You live on Maple Lane? Yes or no?
And
Do you
I-
live on Maple Lane, yes or no?
My address of residence is 20679 Churchill Avenue on my driver's license, certain my property's there, and I have money invested in that house. And they're trying to take it. He is my brother. I got about $30,000. Who else will do that for their father, sir?
Oh,
Not this deadbeat who's got my dad broke.
hang on. Watch your mouths. Now listen, 85-48, don't start swearing in here. I'm as serious as a heart attack now. Stop it.
Yes, sir.
Do you have a lease with him?
A Ridley, sir?
I'm talking to your dad. What did I tell you last week? I said you can't be his representative here. You're not a, listen, sir, listen to me, please. Just so you don't think I'm being mean or anything. I cannot allow people to engage in the unauthorized practice of law, and that's what you're doing right now. You're not a lawyer, and you can't represent him. Period. I can't go over and set up a medical office and act like a doctor. You're not going to act like a lawyer. Now, I thought I made that clear. Did I not make that clear?
Yes, you made that clear.
Then why are you here doing the same thing? I don't care what the reason. Look, let me just try to help you guys. Maybe you can save a lot of people a lot of time and a lot of money on lawyers that maybe isn't quite necessary. What do you mean you put $30,000 into the house?
I got the receipts. I put a whole back patio,
I wanna, you put in a back patio?
all brick pavers, 2 fireplaces, a hot tub. I did it for my mother because.
How long ago?
It's like right around the start on COVID, it got delayed.
Is your mother still alive?
No, she passed away.
When?
18.
So you're telling me you put in brick pavers and what else?
2 fireplaces, a hot tub, but. it's all-
Where's this all
It's
at?
all on at my dad's.
In the back?
Yes, sir. I got pictures and
And you did this 7, 8 years ago?
No, it's a few years ago. I promised my mom
Well,
I'd take care of it.
Wait a minute, wait. When did you do that? What year?
It started in 2020.
But your mom was already deceased.
I promised her I'd take care of it.
Your mom was already
I
deceased.
promised her I'd take care of it. I made a promise to my mom and I honored my own. When I moved in there for my divorce, I promised her I'd take care of it. A tree fell down, destroyed the pool. They paid to have that. My dad didn't have the money. I did, so I pulled it out and I took care of it, like I promised.
You did this 5 years ago.
It started off.
Was there any- was there any- was there-
I sent him over there doing some
Was there
work.
any agreement that he was? You told your mom you were going to do this, right?
Yes, I did.
Because you wanted to be a good son to your mother.
Yes, sir.
And you took care of it even after your mother died.
Yes, sir.
Do you have anything in writing that says your mother, stop, don't interrupt me. Do you have anything in writing that says your father, Don Pittaway Senior here, agreed to pay you? Yes or no?
No.
You have anything in writing from your mother saying she agreed to pay you, even though this happened 2 years after she passed?
Anything I.
Yes or no?
No.
How are you gonna win this? You wanna say something? How long you been living there?
Since like 2018,
18? How much you been paying in rent?
$50 a week, just like he paid, my other brother pays 0. And everything I put into the house, my dad said would be taken off my rent. has said.
Have you been paying the rent $50 a month or a week?
My dad took like 5.
Sure.
Yes.
Have you been paying your father $50 a week?
Yeah, he just took like $500 on my bank account.
No.
They take more than.
Wait.
Gosh, you have this terrible habit of interrupting me. Have you been paying since 2018 $50 per week?
Yes,
How you been paying that?
cash,
Check?
cash.
Did he take 50? Is he been paying you 50 a week? Look. You know what I think?
I have proof.
How do you have proof? Did he sign receipts? How do you have proof? Did he sign receipts saying every week, my son, Ronald Pittaway, paid me $50 to cover his rent for this past week? Do you have proof of that? You have receipts like that? I'm asking you a question.
But make sure I don't interrupt you, sir. I got my bank statements right there. My dad took it out of my bank account. From the bank, I got them out there. They'll verify that he took it out.
For 6 years, hang on,
He's on my bank account.
for 6 years, he's been taking $50 a
He
week?
takes money whenever he wants to.
Have you been taking money out of his account?
Here's what happened.
Oh,
I didn't even know that he was on the account. And then all of a sudden, I found out he hasn't been paying me any rent. He pays the rent. He's paying.
Who's he?
Ronnie doesn't pay nothing.
Who's he? Don Pittaway Jr.?
You pointed to this son. Wait, you pointed to this son, right?
Right.
He's been paying rent.
He's been paying, but the other guy right over there has not. And every time I try to collect from him or something, no, I ain't giving nothing. Oh God, it was like 6 months ago or something, I found out that he has a bank account where I'm at, and my name's on there as runner-up or whatever you want to call it. So I
Runner-up.
start taking money out of there.
You did?
Just a minute, he found out about it, and so he cut me off of there. I can't go in there and get money out of the bank anymore for my $50, because he's killed me on.
You kind of lost me. Who's on the bank account?
He's the head on the bank account, and I just found out by accident that I was on there. So I said, well, good, then I'm gonna start taking my $50 a week.
When did you start doing that?
Oh, what, about a year ago or something like that, whatever it was, I would just take it, $50, and he found out, and then he just cut me off of there. But for years, he didn't pay me nothing. When my son here did.
Even if you've been paying, you have nothing here. You have nothing. He has a right to kick you out. You guys didn't sign a 10-year agreement or anything, did you? He has a right to kick you out.
everything is verbal.
All right, well, that isn't good enough.
I understand that part. But he still can't change the locks and throw me out without evicting me.
You didn't do that, did you?
Yeah, he did,
Who's he?
my brother. I
I
told him,
also got
You guys are trying
criminal
to,
complaints against.
you guys are
for
trying-
malicious destruction of property. I'd like to let you see if you'd like to see them. I'm going.
you guys are trying to be your own lawyer. That never ends well. Never.
Oh, how do families get this angry at one another? I don't get it. You have to heed my advice. You cannot represent your father. He seems completely competent to me, by the way. Why don't you have a seat, Mr. Don Pittaway Jr. in the back? And Don Pittaway Sr., would you like to stand at the podium or would you like to have a seat at the council table right there?
I don't know.
No, I'm just asking you how you're going to feel more comfortable. You want to stand or you want to sit?
Well, probably sit, I guess.
Sit. Why don't you sit down?
You're not getting anywhere with me, Ronald Pittaway. $50 a week.
on Churchill and Brownstown, that's a pretty nice area. Will you move me in for $50 a week? I'm just kidding.
No.
I don't want to hear anymore. This is silly. Do you also live on Maple Lane?
Yes, I also live on Maple Lane.
Why
I
do
had to
you,
move in there because they changed lots on me. Well, I was helping my buddies when his dad died, emptied out his house. They lived on Sutton Farms. So I was helping him, his dad had a hoarder.
you have, I'll tell you what I'm gonna do.
They've got a washer, dryer, a hot tub.
I don't even think I have a triable issue now. I really don't. I have to have a triable issue. I'm telling you right now, Don Pittaway Jr., don't stand up at that podium again and act like you're representing your father. Do you hear me?
I understand.
This is kind of all coming back to me now. I'm adjourning this 1 week. You guys want to come in and tell me the same kind of thing? I'm going to order you out in 10 days. You want to come in here if you've got a lawyer or some legal argument to make that's legitimate, then I'm going to find there's a triable issue. So far, I haven't. I find this more sad than anything. I really do. I get this families fight, dads and sons and mothers and daughters and mothers and sons and dads, and daughters, and but I don't understand it. I'm adjourning this case 1 week. If you don't come back with some legitimate legal argument other than I honored my mother's wishes that she asked me before she died, and in 2020 did some work around the house. Stop. You look like you were gonna cut me off again. Then I'm gonna order you out. You wanna try some other legal theories? Feel free. I'm giving you 1 week to get a lawyer to do whatever you wanna do. Maybe you need to find another one, Don Pittaway Senior. I don't care. June 23rd at what time, Jen?
10:30, Your Honor.
At 10:30 in the morning, and that's it. I find this incredibly sad. Good luck.
Can I get my property out of there?
I don't know what your decision is.
Well.
Are you saying you want to
if you
relinquish?
tell me, like I said, that I'm gonna have 10 days and I wanna be able to go get my stuff. I got the doors locked. I have to call the police to get in.
Sit down. You're pushing me. Don't push me. Now you want to stand from the pews back there and start debating why he shouldn't be able to do that? You're not the real party of interest. You got no business being here except to observe. How many times I got to tell you that? Wait. When I issue this order, this judgment, if I decide to enter the judgment, I'm still going to give you a week if you want. You guys, sir, you're going to let him come in and get his property. If I have to treat you all like children and have the police stand by and set a specific time, then I will do that. Stop. Stop acting like children.
He was there the other day and taking his stuff out.
Is that true?
Still some left
Some of the
in
stuff
there.
I put my washer and dryer, my dad tried to.
Is that true?
Yes, but they wouldn't
Is-
let me,
hang on.
they wouldn't let me in the house to get the other stuff.
Yeah.
No,
Hang
they wouldn't
on.
let me in the house. Mark locked the door.
Stop.
He doesn't own
Stop.
a washer or dryer.
I got proof.
I'm getting tired of hearing you say you have proof. Where's your proof?
I bought the washer and dryer from Sears. It was on my credit card. Please.
How many years ago?
Shoot, about 20.
You're not taking the washer and dryer, okay? You're not taking the washer and dryer that you bought 20 years ago. What else?
My hot tub out the back.
Do we have a problem with him taking the hot tub? Not you. You don't say a word, Mr. Pittaway Jr. You have a problem with him taking his hot tub?
Nope.
What else do you want besides your hot tub?
Like I said, the freezer and the two pitchers that are downstairs that Sean had stored that they wouldn't let me get access to.
What's the you have a problem with him taking the freezer?
No, it's empty.
You have a problem with
Down
it?
there.
What's the pinchers? I don't know what you mean.
Pictures. My friend started some of his stuff there.
Pictures.
He's got some antique.
What kind of pictures?
They're antique pictures. They were sitting on top of the freezer.
Well, you gotta be more descriptive.
They're my friend Sean's. When we were moving his dad out.
You gotta be more descriptive.
Two big pictures, antique pictures. He's
Of
got,
what?
they're just antique pictures he had down there. He was
I know,
storing-
but are they to depict the baseball field, World War II? What do they depict?
I couldn't tell you.
Well, then why do you need them
Because
so
they're my
bad?
friends, I need to get them out of there. And his motorcycle's in my dad's garage. They were storing it for my dad. My brother got mad, pulled the gun out, poked me with it.
Oh my
On
God, you
January
guys are out of
27th.
control.
Listen, and
Hang on,
but
hang on. Do you have is there a motorcycle in the garage?
They come over to get it, just the other day, and, they couldn't get it started, so he towed it back into the garage. They're gonna come.
Is that
get it.
true?
Yes,
Okay, so it doesn't sound like anybody disagrees about the freezer. Hang on, hang on, or the motorcycle, or the pictures. I guess, do you disagree that he can take the pictures?
They're his, take them. We told him he can have that freezer, and, what else is that, Donnie?
What else do you need?
that's just everything I have. I don't know where they put everything.
Hang on.
They took my room, put stuff in the. they put
Mr.
stuff in the
Pitaway,
box.
Mr. Pitaway, I want a list from you. So far, you've told me 2 antique pictures that you don't have a clue of what they depict. Which I guess if I wanted a picture, I'd at least know.
Can I suggest something to be just real quick about this, to save the board's time? Can I have 30 days, I'll have it out, I'll go over there with my dad, we'll go through this stuff, I'll get it out in 30 days. And if you don't hear from us, you know everything's good, but give us 30 days, I'll have it out. And then.
Hang on.
Is that fair?
I can adjourn this a week.
30 days.
Why do you need 30 days? Where are you working at?
General Motors, we're there every day of the week.
You've got 1 week. Come on.
We have a trailer, I'm trying to figure, I gotta find storage and everything else, I mean.
I think Don Jr. Pitaway should stay out of this, to tell you the truth. Don Senior, can you collaborate okay with your son here? I'm talking about with Ronald.
I'd rather handle it between my dad guys.
What's that?
I'd rather handle it between my dad guys. And I'll talk to him on the phone, tell him we're coming over. And if, like I said, it's gonna take about
All right.
30 days.
Okay, hang on. What do you want to do, Mr. Pitaway Senior?
I don't know why it's gonna take 30.
I don't either.
How do you pick up a hot tub?
You get a truck and you get some friends and they come and help you. You should be able to do that today if you want.
That's not how a hot tub works.
Okay. Well, how do you intend to move the hot tub?
Well, I'm gonna get some money, I'm gonna call people that deliver and see if they'll come back and get it. The guy that dropped it off, I'm trying to get a hold of him and see if he'll do it. Get some people, where it's at, you kind of gotta wheel it.
He filed this May 20th. How about I'm gonna adjourn it 1 week. I'm gonna let you guys figure this out.
Can I get 2?
I'm not gonna be here in 2 and I don't wanna move at 3. Do you have a problem with 3 weeks? If I adjourn this 3 weeks?
I'd rather do it sooner than that, but whatever.
I'm not gonna be here June 30th, so it's either gotta be June 23 or July 7th. Is that okay? July 7th?
I guess.
At what time, Jen?
10 o'clock.
At 10 a.m. All right, that's what I'm doing. Okay? July the 7th at 10 a.m. You guys come back. Don Pitaway Jr., I think you should probably really stay out of this, and I don't think I can emphasize that enough, and I know you're not gonna listen.
No. We have a younger son, and Donnie's been taking care of him or whatever. That's why he's basically running everything, because, you know,
All right.
I'm gonna be 85, and I ain't got that long to go.
And I mean, and that's what exactly my point is. It's a sad commentary. You guys are fighting like this. Jeez. Look, I'm gonna move this.
I don't hate my son. He just acted up a few times, that's all.
Okay. I would hope that you guys could resolve this. Really. I don't want
Well, we
to
did the other day, but let's just see what's happening, so whatever.
be
He's gonna
nice.
get all his stuff out of the
This,
garage.
if this is you and your brother fighting, let this be you and your brother not seeing each other, but stay in touch with your dad. July 7th, come on back here. You guys see what you can work out in the meantime, will you? I really mean that. Good luck. Don Jr., maybe you should stay out of this.
No,
But don't come up to the podium again, sir. Did you hear what I said? Yes?
Yes.
Okay. See you in 3 weeks. Good luck.
First case, People versus Larry Lee.
Good afternoon, Your Honor. Mary Tanha, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes,
Okay, could you please state your name?
literally.
What is that noise?
Right. Shouldn't you check? I don't feel safe.
What
Why
is-
are you just pointing? What? It'll stop at some point.
I feel very safe, Your Honor.
Wow, I know. He's like, no, you are all over it. All right. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMB against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge, because we want it documented for potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
Hold it, but does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this
Well,
case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that.
Go
Go
ahead.
ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's your name?
Mary Rubio, Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know, are you a lawyer?
I was,
Mr. Lee, no, to my knowledge, no.
so I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorneys. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Quanzi agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you. Can we get Mr. Lee out? No, oh, is he? Okay, all right. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marie Tin, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry.
Mr. Rubio. Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Arabo sent me, as well as Mr. Burgess and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No,
No,
Or an
Your Honor.
attorney?
It's with Mr. Arabo, who's the attorney for the victim.
All right, and basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Arabo has additional information or different information, he's welcome to.
Yes, Mr.
Yeah,
Arabo.
yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
Because it would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
Well,
Mr. Burgess may not have done.
and that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that, but I just wanted
Your Honor,
to
if I
make a
may.
record. What, can I just finish though?
Let her finish.
Mr. Lee
Sure.
indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if maybe if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Ms. Tana.
Mr. Arabo had some trouble with the drum.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Rob was making about extortion. That's not something that people are gonna get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quasi, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quasi not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. If it has gone to law enforcement now, and we can follow up.
Mr. Rob.
Your Honor, as you know, I'm a defense attorney. I think it's Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what is being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the cracks because in over 10 years of practicing, I've never seen something like this where a victim turns into a defendant. What during a pending case? Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this, and it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen to it already.
Can somebody send it to Ms. Weidling and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and sort of listen to the call. I can give my decision.
You have to go back.
To you. I'll handle that coming back out. Get your name, please.
Clearly.
Okay. The issue is in this case that, first of all, we're adjourning the hearing over.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the,
Oh,
I'm on the bench, but I'm not doing these.
okay.
Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025. And that's another 12 p.m. start because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr.
No,
Lee has
and
told
I
me.
understand that.
And Mr. Lee is
I think
about
when
jumping
you-
out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in
Okay.
the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, and I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. Lee, you might as well stop right now.
I have the text
Because
message.
no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what you, how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Take you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
Pardon? I am.
Are you still on the record? You know, I'm not sure who this kid is or what he's capable of or what sort of messages he can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision in.
Yeah, one of those, Your Honor.
But counsel, why don't you let us know how you really feel? I know. All right. We'll take care of that.
I think the courtroom's been through enough today.
Contact.
Thank you. Appreciate it.
Thank you, sir.
Take care. Bye-bye.
Thank you, Mr. Rubin.
Good morning, Your Honor.
Good morning. I received notification from Mr. Blauswingen that maybe he was going to be present with you. Are you just gonna handle it then? By yourself? I think he had his office set up for you.
I'm sorry, Your Honor. Are you
Oh,
referring?
no, I'm not. I'm sorry. I'm talking to Officer Alinger.
Oh, okay. Sorry.
Sorry, I apologize.
That's okay.
I wasn't made aware of counsel being present.
If you would like to be present, are you outside the courthouse or are you just at work? Okay,
Yeah.
if you would like to, you could go to the prosecutor's office and DPA Blauswingen is waiting for you.
Oh,
If you'd
okay.
like to sit with him during this matter.
We can certainly do that.
Okay, so Mr. Huff, I apologize. I will call you back within 5 minutes. So that way Officer Alinger can go in and meet with him. Is that okay, sir, then? Okay, sounds good. So I will call you, I'll just wait until I see you pop up in the Mr. Blauswingen pop up in the waiting list, and then I'll call you in right away. Okay, sir?
Thank you, ma'am.
Okay, thank you. All right, let's just go. So let's do Nerlich first. Because I don't think he knew that. Bolt. All right, Mr. Nerlich, I see you're here for one matter, Stephen Bolt, 5A02-95393.
That's correct, Your Honor. Good morning.
Good morning, sir. If you could please begin with your preliminary motion.
Your Honor, we move under ER 602, we move to suppress for lack of personal knowledge. Looking at the police report that was attached to the citation, I don't see any actual knowledge from the police officer nor any source from which he got this information. These are just statements of fact. And so given that there is no personal knowledge under ER 602, we move to suppress, and then pursuant to that, we move to dismiss.
Okay, let me just go ahead and read the narrative really quickly. What is the charge? Improper lane usage? All right, I will go ahead and grant your preliminary motion. As such, I'll go ahead and suppress the very short narrative that was provided by the officer, and as such dismissed for lack of foundation.
Thank you very much, Your Honor. I appreciate it.
All right, thank you for your time. I believe that's it.
Thank you, Your Honor. Have a nice day.
You as well.
Thank you.
We can do door really quickly. I don't see.
I don't see.
Okay, how about okay, Huff was
Door.
okay. All right, so if you could please unmute.
Hi, Judge, can you hear me okay?
I can, thank you. Just to be polite, is your last name Dore? I see that there's, okay, Dore.
Yes,
Okay,
that's exactly right. Thank you for asking.
Thank you. All right, sir, so I see that you're here for one matter, Corey Flanders, 5A03366623. If you could please begin with any preliminary motions.
Sure, absolutely. So I have two motions for the court this morning. First of all is that I'm moving to exclude the affidavit in this case under RCW 5.50.010. Under the subsection 3, signing requires that for a law enforcement officer that they include their full name, department or agency, and badge or personnel number and attaching it in the signature block. I've reviewed the discovery that was provided to me by the state, and I see that there is, while there is a name and there is what appears to be a badge number, there is no agency ID included in the signature block, and I would ask that the court find that invalid and excluded the entire affidavit for that reason.
Go ahead and grant your motion. I see there's lack of agency in the signature block. As such, I'll go ahead and suppress the officer's report and dismiss for lack of foundation. I believe this is a sole, yes, this is a sole charge. Okay, all right. All right, sir, so I have dismissed this matter.
Okay, great. Thank you, Your Honor. That's all my cases.
Okay, thank you for your time.
Thank you. Bye-bye.
Do we have Stringer? Yeah, Violetta Stringer.
I don't agree.
Right, Miss Stringer. So it seems that your client is here as well. I don't know. I think this is another time that your client's appearing again. I don't know if you just want your clients to appear with you.
And Your Honor, I will apologize to the court. I'm not entirely familiar with all of the Cowlitz County procedures. We anticipated being able to present some
Okay.
mitigation information to the court today.
Sure, absolutely.
And I also must confess, Your Honor, I do have 3 small exhibits that I had hoped to provide to the court. I had been negotiating with the prosecutor. I did not realize that they were entirely not a part of the infraction process.
Mhm.
And so by the time I realized it was too late to mail, I had intended to drive up to Cowlitz this morning. But I will confess, Your Honor, I'm 6 months pregnant and I had a little bit of a health issue and I made the decision to just stay back. I can share my screen with the court and with those exhibits and mail them immediately after, or I can also maybe in a couple of days drive up and drop them off, if whatever the court's preference is. Or if the court for this reason prefers that we set over to next week, absolutely understand as well.
That's okay.
Thank you.
No, I understand. So, if you want to just share your screen with me, that's fine. If that'll be able to go
Absolutely.
through, that's fine. I can also admit, do you want me to go ahead and admit your client so that he's present?
Yes, Your Honor, that would be great. Thank you.
I'm gonna go ahead and bring him in right now. And then you can either email those in, mail them in, just so that we get it after the fact so we can have them attached to the record. Okay, sir. So your attorney is present. I believe that you are going to be called to make some statements. So for the time being, if you could just stay muted and listen to your attorney, all right? Okay, thank you. All right, Ms. Stringer, so go ahead with any, I guess, say preliminary motions.
And Your Honor, I had just hoped to present on behalf of Mr. Stepelnikov our mitigation. I don't know that he's prepared to
Okay.
speak, but if there are any questions. So,
Sure.
Your Honor, in this case, I'm sure the court has the tickets before it that he has. So Mr. Stepelnikov has some English limitations. He's a young person. He's 23. He is new to this country. And what happened in this case is he was hired by, to be frank with this court, from my view, a less than scrupulous company. He worked with them for about a month and a half. He started in or towards the end of January, and he quit in March. I believe it was March 12th. So what Mr. Stepelnikov shared and what I will show the court with a couple of exhibits is he was very reliant on the representations of his employer as far as what he needed. And they said that, they guided him that, hey, if you're underweight, you don't need a CPL, you don't need a CDL, you're fine. So he trusted in them that they were not overloading him. However, within a short few, as noted in the police report, he was stopped previously for overweight. He didn't have a medical certificate. And he forwarded all of these to the employer and was asking, what do I do? And they told him, oh, these are not not a big deal. You just we'll take care of these. We will provide you with a lawyer if you need it, but just keep driving. He also shared that he started to become really concerned because there were a lot of problems with the vehicle he was driving. So he was often having breakdowns. So he started to become concerned for his safety. And then this incident occurred. And so I will sort of start with the first ticket where he did not follow the instruction to pull over at the weight station. And Mr. Stepelnikov shared with me that he was very confident that he was under the required weight And he also it was suggested to him by his employer and other people in the trucking business, and I'm not as familiar with it, but there's an app apparently that truckers use, and it's called Trucker Path, and it sort of lets them know when a wait station is closed. So he was driving confidently thinking, I don't have any issues with being overweight. They have assured me. And he was looking at this app, which told them that the Kelso station was closed. And I actually ended up, I don't know why I didn't do this earlier when he shared this with me several weeks ago. Yesterday, I downloaded the app and I went through the entire history all the way till February 27th. I apologize. And I was able to locate that it does say that. And I'll share my screen with the court right now so the court can see. Oh, it looks like sharing is not turned on, and I will send a request if
That's okay. Can you just
Okay.
raise your right hand, please?
Yes.
As an officer of the court, do you swear to tell the truth and only the truth?
Yes, I do.
Okay. All right. Thank you. Please proceed. You
Thank
can
you.
just tell me you just stated
Yeah.
what it would be, but
Yeah. So I'm looking at the application here, and for February 27th, there appears to be like times, and they're very short in time, and it'll say either actively monitored, open, or closed. And for the period of between 6:52 a.m. and 7:16 a.m., it's marked as closed. And in looking at the report, the officer noticed Mr. Sepelnikov's vehicle at I want to say it was 6:58 a.m. So he would have been relying on this information. And again, I looked at the statute, and it does say that, if you have an overweight vehicle, it doesn't matter whether it says it's closed or not. But for a non-native English speaker who's new to this country, who's relying on these representations, looking at this app, this could be confusing. So then he gets pulled over, and he's pretty surprised that he's overweight. So Mr. Sepelnikov shared some text with me that he contacted his dispatcher, and he was telling the dispatcher over text message, I am shocked, I've been pulled over. It's showing that I'm overweight. I was driving very confidently. And I Google translated the text there in Russian. I can read them directly into the record. So this is with the dispatcher. He says, and this is at, it looks like starting at 7:23 a.m. So he's still pulled over, and he says, I was stopped by a cop and put back on the scale. I was sure that I was not overweight with this load. I have 27,100 pounds. And Sepelnikov says, but how I looked, there was maybe 14 to 15. I was driving confidently. I thought my maximum would be 25 out of possible 26. And the dispatcher replies with no concern for his situation, and says, why are you only in Washington? You should have been in Oregon by now. Sepelnikov says, I looked at the map. I didn't have far to go. I stayed to sleep so that I could be there early in the morning, just as the drop from 9 a.m. starts. And the employer, so then he sends this was the dispatcher, and then he sends this screen grab to his supervisor and says, now he's talking to the supervisor about what he's sharing with the dispatcher and his concern. The employer says, let's go to the scales without any bullshit. Try to come to an agreement. So Mr. Sepelnikov, he's at this point confused. So he starts to pass the phone back and forth between the trooper and the employer. And this is what Mr. Sepelnikov is writing now. He said to call you. He said, I can't move without CDL, without a permissible weight of 27,000. And the employer responds with DOT physical exam plus, can we remove truck from the trailer? So my assumption is that this was intended for the trooper based on whatever call they were also having. So then the texts go on in English here directly, and this is appears to be between the trooper and the employer, and the employer is again attempting to ask the trooper to allow him to continue to move even though it's not allowed. So he says, "Hi, sir, we're trying to find some road assistance services to you, but there's no one shop for 50 miles away. We've got a medical card and my second CDL driver will get all 3 cars from his trailer. I'm going to send this truck to my shop in Seattle. I have a shop there. Is it possible to drive to a shop in Seattle without any cars on trailer?" And then he says, "Ask this of the cop." Mr. Stepelnikov says, "1 second." And then this appears to be a response from the trooper. "If the vehicle is placed out of service for equipment violations, then it cannot proceed until it is fixed." The employer responds, "But there's no shops who can do road assistance. The nearest shop is 40 miles away, and if you let my driver to go with an empty trailer and we've got a medical card, it's going to be safe and more faster. Appreciate this." And then the trooper appears to use Google Translate to say, "If you have a CDL driver, come drive this. The breakaway still has to be fixed on site." So this is, I have some additional text messages, but this is cut from that incident. And Mr. Sapelnikov had previously been violated for not having a medical card or a medical certificate. And he had asked the employer, "What is this?" And he said, "Oh, they've just been asking for it recently," is what Mr. Sapelnikov has shared with me. So at this point, with this particular stop, it really came, he's been there for, at this point, about a month. And he's starting to realize, like, this is a lot bigger deal than they're presenting to me. So Mr. Sapelnikov went the next day on his own and obtained a medical card, a certificate. And I have that for the court as well, which we will send. And it does have a stated date of February 28th. And I also, checked the license number of the nurse practitioner who provided it, what appears to be active and accurate. The employer, even after this incident, continued to assure Mr. Sapelnikov, "You're going to be fine. These tickets get taken care of very quickly. We're going to provide you with a lawyer." Mr. Sapelnikov became very worried because they're still continuing to push him to drive, is what he shared. And he was now very paranoid about being overweight and was constantly asking about this. And as I said before, there were continual problems with the vehicle. So he felt that he was driving to like his detriment of his safety. But he was worried, he doesn't have a lot of money. He's not going to get paid. But finally, to his credit, I will say, he just got to a point where he, even like if they were going to cancel his lawyer, if he didn't continue to stay with him, if they were not going to pay him, he just came to understanding that this was absolutely not safe for him. So I believe this was March 12th, he writes, or it was
Ms. Stringer, and I apologize to be interrupting. So I understand all of this. I understand his statement. I understand that he's saying that he feels uncomfortable and all this stuff. I understand that you said that he went and asked him about a medical certificate and they said this is something new they're requesting, but he obviously knew that it was something that he could go and get because he got it the next day post the infraction. I guess my question is, while all of this is, I'm very sympathetic to his cause. He obviously is a non-native English speaker, who just trusted in his company. Do you have any like legal basis of the arguments rather than just like a, like a heartfelt sympathy arguments? Do you have anything in regards to like a statutory argument?
Your Honor, in looking at the statutes for these infractions, I did not see a specific intent requirement with them. But I guess my argument would be that there was a lack of knowledge and that he was misled by his employer. that would be the one argument that I would offer. I would, in the hopes of mitigating these infractions and asking for, if the court would be, and again, I recognize it's a big ask. I have to ask on behalf of my client because these infractions on his record would make a big difference. Not even for purposes of CDL. He has quit. He has no intention of rejoining this company or trucking. He, by training, is a chef, and he's working at Emish Market, which is a Ukrainian store in the Kent area. So he's not looking to return to this, but this could have other consequences for him having these types of infractions on his record. So we're just asking for the court to consider this as mitigation and lack of knowledge.
And what statute are you referring to lack of knowledge? Because usually lack of knowledge has to do with the police officer, not the actual individual.
I do not believe any of these statutes have a knowledge requirement. I guess I would just make as a general argument that he did not fully understand what was required of him in these situations and relied on inaccurate information.
It's just, yeah, I mean, it's just that argument's just a little attenuated in the sense that, he didn't know better, but I mean, he obviously had asked about the medical certification and they just said, oh, it's not something you need. And then he went and took the initiative and got it himself the next day. So it just seems that that's, I am sympathetic, but it just seems like a lot of that is just pushing the blame around. And I'm sure his past employers maybe not very scrupulous and like just does things that are maybe not up to code and safety, but I mean, that's just asking me to give him a free pass. That's what you're asking. And there's just no legal basis for that. That's just, asking a judge to be like, hey, can you let it go? Even though he has another pending commercial driver's license violation, I think.
That's the
oh, is that part of this?
That's part of this case. So this was this one incident. He
has another one, I think, pending. That's 75. That ends in 75. So he has another one pending.
The 75 is the criminal charge from the same incident.
Oh, okay.
And we've negotiated that with the prosecutor to a non-moving violation. We expect to enter it's an infraction and expect to admit to it on Monday at the trial readiness hearing, Your Honor.
Okay. All right. Okay. Okay. All right.
And Your Honor, if the court were willing to if the medical pass is very clear to the court where he knew he made the decision then the next day to just do it on his own, we would ask for the court to consider the other infractions as well, the overweight infractions, the failure to follow the device, failure to follow the instructions to pull over at the weigh station. I'm not having the correct name.
No, that's fine. I mean, I get so confused with all this stuff too. I mean, it's so out of my realm understanding all this weight stuff and the vehicle enforcement stuff. I understand.
Thank you, Your Honor. I will say there's one more infraction that I did ask Mr. Sepelnikov about, and that had to do with providing falsifying his logbook as well. And this is where the trooper noted that he had put himself out of service and continued to drive. And he shared with me that he certainly never intentionally would do something like that, or he did that. We went over when it occurred, and he did talk about the fact that they use an application or some sort of online kind of a device to place themselves in and out. And that there are times, and it looks like at this point he was driving to Idaho. And so while he had no recollection of doing this, I pointed this out to him in the report. He did say that it could have been an issue where he was in a spot without reception, but this part he denies knowingly doing. So if the court would even consider dismissing some of these or reducing some of these, we would be appreciative.
Because I was going to say, if he's not a CDL driver, I don't really understand how this would really affect him to that extent. I will just make one statement right now.
Mhm.
There is an argument you can make that is not being made.
Okay.
I'm not going to give you any more insight. I feel like if you want to just quickly look at the traffic violation affidavit and you want to go to the end, so I can just move on because I have an officer who's waiting to testify.
And Your Honor, it would appear that I suspect there's an issue with either notice or the way that this was signed by the officer. I can, and on that basis, we would ask for the court to dismiss.
Yes, there's lack of agency in the signature line, and based on that information, I will go ahead and suppress the affidavit, and as such, I'll go ahead and dismiss the charges for lack of foundation.
Thank you, Your Honor. Would, given the court is dismissing and I've read into the record these exhibits, does the court still want me to mail them?
No, you're fine.
Thank you.
Thank you. All right.
I
Thank you for
appreciate
your time. Yep.
Thank
no
you.
worries.
Have a good
Thank
one.
You as well.
Bye.
Let's
Bye.
call in Huff. Okay. All right, Mr. Sapilniuk, you're good to go. Thank you, sir. All right. Looks like everyone has found each other, so that's good. So if everyone could please just unmute. I apologize for the delay. We just had a lengthy explanation on a matter. So we are here in Radu George 5A02711160. Mr. Huff, or why is Mr. Ellington in here? Oh, I didn't.
I don't know, Your Honor. I just unmuted.
Okay. Thank you, sir. I apologize. I'll call you in shortly. I somehow accidentally called into the wrong matter. Okay. So Mr. Huff, I see that you did issue a subpoena in this matter. So if you would like to begin with any preliminary motions or any way that you would like to begin, sir.
And good afternoon, Your Honor. Andrew Huff, appearing for Radu George 5A0271160. Your Honor, if I could first of all make a motion to suppress and dismiss the actual citation in that it's improperly certified under 550010 subsection 3E. There is no department or agency listed on the ticket itself pursuant to that statute. Without that information, this would be improper certification of the ticket. On that basis, motion to suppress and dismiss, Your Honor.
I'll go ahead and grant that motion. I do see that there's lack of agency in the signature block. Because of that, I'll go ahead and suppress the notice of infraction. So then there is still the question of the affidavit.
That is correct, Your Honor. And without the ticket, which is essentially the charging document, we are just simply left with an affidavit. We don't have that crucial information that is contained on the actual ticket. So without the charging document, which is the ticket, again, we're just simply left with an affidavit. That would be insufficient, would be my argument, Your Honor. So my motion to dismiss on that basis.
All right, so based on that information, I'll go find that there is lack of charging documentation. And based on that information, I will go ahead and suppress and dismiss for lack of foundation.
Thank you, Your Honor.
Thank you. Please stay. Not you, Mr. Huff. Thank you. I just want to release the officer. Thank you for your time, sir. All right. Hello, Mr. Blauswingen, and then Officer Ehlinger. I just wanted to talk to you really quickly. Maybe you have been made aware, a lot of arguments that attorneys are making right now are based on 5.50, which is lack of agency in the signature block, which pretty much says that that needs to be in both the notice of infraction and any affidavits. I've tried to reach out to some agencies in regards to this, have some pushback, and then their statement was that, well, there's a law enforcement officer number that's included in the notice of infraction, and so that would be sufficient to act as both an agency signifier. But then the issue is they say that attorneys are arguing that is not put in at the time of the infraction. They're saying that that's just like auto-populated on all documentation that you have. So it's not like a present sense signature. It is made in a past situation. And I don't know, it's very attenuated, but I just wanted to let you know, is there any way on any of your documentation to put your agency in the signature line?
The document comes from Sector, which is what the whole entire state uses. And the agency is listed on the infraction on their Washington State Patrol, and our ORI numbers on there. It's not in the signature block, but I mean, I can't do anything about that.
Can you do it on your affidavit? Because I've seen some people start putting it in, or is it like an auto-populated signature that goes in?
I've got my, like my history as a commercial vehicle enforcement officer. On
Yeah.
I can certainly add it. I mean, and I keep, you know, the perjury statement on there because I want that incorporated into it.
Yes.
Again, we can certainly add it. It just,
I know it's redundant. I know it's dumb. It's just this stupid 5.50 just really is messing us up because they're not saying it's made in like a present sense. It's like an auto-populated document. I don't know why there's a specific signature block that says there has to be name, badge number, agency, and there's just no way around it. So even in the affidavit, if you can just put your agency acronym, just like a little one, that'll really knock out a lot of arguments being made.
even just the Washington State Patrol, because that is
Just put it literally WSP, just write it in anywhere. It can even blur into your name. I would accept that. If you just put WSP anywhere, that'll make it very difficult for them to make that argument.
And we're in the process of moving from Sector to Tracks, which is another similar program, and I'll make sure that they actually get that in there because it gets generated when the infraction is issued.
Absolutely.
So it's pertinent to the time, but okay.
Yeah, and I mean, I've made those arguments many times before too. I'm like, agency's redundant when there's a law enforcement number specifically associated. If you look that up, it'll track back to the agency, and then their arguments back is that's not specifically what it says in 5.50. They have to have agency stated in the signature block, not listed above in the documentation. It's just, it's so specific, and it's just been throwing away a lot of reports. And I just want, if I can pass it on to you to pass it on to your fellow coworkers, like I would just love to enforce these better. So, you know, if there's anything that can just assist with that, if you could just pass it on, I'd really appreciate it.
Thank you very much. I will. The RCW is 5.50.
Gosh, I have it written down. Let me look it up. So yeah, it's signature line RCW 5.50. Let me tell you what it is. Uniform unsworn. I think it's 5.50.010. They use, which one do they use? That's the one that they blanket statement, but there's one I think also.
Okay.
I've been trying to write it down. Because they do D. Yeah, because then there's also general rule 30. So they use specifically subsection 3D, and it's to affix or logically associate the declarant's signature in the manner described in general rule 30. And then general rule 30 is the one that says specifically, general rule 30 is that you want to look at. So it just says authentication of electronic documents. If you look through that, it'll specifically lay out what you need to have in the signature block. For some reason, for any officers, they're very specific of agency. And it's always agency that's not in there because I think it's an auto-populated signature line, or it's not something that's been done before. And I think that our legislature switched it up on us and sort of is making it a situation for officers and traffic infractions. So I just want to make sure that, just to get it out there, so we don't, we're not wasting your time.
Thank you very much.
Okay. All right. Thank you for your time. I'm sorry that this was, you know,
I will learn.
yes,
Yeah.
but hopefully that can be passed on and then we don't have to deal with these situations going forward.
Yes, ma'am.
Thank you, Your Honor.
Thank you. Thank you.
Okay, this is 251792, at least on one of the defendants, but I have here four separate defendants, the People versus Montel Deshaun Ford, Zachary Xavier Collip, Julian Ray Santana, and Mark James Mascot. Who's my officer on that?
I am, Your Honor.
All right, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state your name for the record?
My name is Detective Jordan Chamberlain.
Okay, have you read the type complaint that was filed with the court?
I have.
All right. And can you state the facts that support the issuance of the arrest warrant?
Yes, ma'am. On 6/15/25, Taylor officers were dispatched to 20428 E-Course, Big League Brews, for a shooting that just occurred. Upon making location, officers were met with Javion Beverly, who was suffering from a gunshot wound to his chest. Officers rendered aid, and the Taylor Fire Department transported Beverly to the Dearborn, Maine, with a collapsed lung, broken rib, and a through-and-through gunshot wound to his chest. Officers began talking with people on scene and talked with Sol Perez, who stated the following. She was at Big League Brews with her boyfriend, victim Dominic Nino. They were outside the bar, and she was waiting for Nino to get off the phone. A gray SUV pulled up to them, and a male from inside the vehicle began arguing with her. During the argument, the suspect stated, "Run me your shit," and he produced the tip of a firearm. The suspect then turned to Nino and stated, "Matter of fact, both of y'all run me your shit." Run me your shit is slang for a robbery. She and Nino then began running away from the vehicle when the four males, later to be ID'd as Montel Ford, Zachary Collip, Julian Santana, and Mark Mascot, all exited the vehicle and chased the pair down. All four then began punching and kicking her and Nino. She was also struck on her head with a firearm. The group then stole Nino's shoes and fled back to the vehicle before fleeing the location. A short time later,
They stole his what in shoes? His what in shoes?
They stole his shoes.
Okay.
A short time later, the males returned to the bar and began walking towards the front. A group of individuals began confronting them about the robbery, and the group stated, "Yeah, it was us." The group then got into an argument with Beverly over the robbery. Beverly then began getting jumped by Mascot and Collip. Santana then walked over to the crowd watching, brandished the firearm, and then turned back to Beverly and joined in on the assault. During the fight with Beverly, Santana discharged a single round, striking Beverly in the right side of his chest. The group then fled the location on foot, and Montel Ford fled in his vehicle. Beverly and Sol selected Santana correctly out of a photo lineup, indicating that he was the shooter. Collip, shortly after the incident, turned himself in and confessed to the night's incidents under Miranda. Ford was interviewed the night of the incident and confessed to being the driver of the incident in a voluntary interview the night of the shooting, and ID'd Mascot through surveillance footage.
Who ID'd Mascot?
Ford did in his voluntary interview.
Okay.
And Mascot's phone was found on scene.
Okay. Who identified Collip?
So he actually identified himself when he turned himself in.
Okay, Collip turned himself in, Ford confessed to being the driver, and Santana, all under Miranda, Santana confessed to being the shooter.
No, so Santana was ID'd through photo lineups with the victim of the shooting, Beverly, And one of the victims of the armed robbery, ID'd him on a photo lab as well.
Okay. Okay, and did you sign the complaint before you sent it over to the court?
The first copy I actually forgot to. The second copy that's with the court, if it's not already there, is sent over.
Okay, yeah, I don't have this signed complaint in my pile yet, but you've indicated that you've sent it over and signed it?
Correct.
Okay, then I'll get that and sign it upon receipt. Let the record indicate that I find probable cause to believe the accused committed the alleged offense, and I'll therefore issue the warrant.
Thank you, Your Honor.
Thanks. I don't need to ask your position on bond on that. There's only one in custody, and that's Colin, correct?
Mr. Santana is in custody. He's down at the juvenile facility.
Okay.
So Mr. Santana is actually a juvenile that the prosecutor's office denied or has decided to charge as an adult.
Okay. Okay, thank you.
Thank you.
Sir, can you tell me your first and last name?
Zachary Collop, Zachary,
Okay, thank you. This is the people versus Zachary Collop, who is defendant 251792.
Good afternoon, Your Honor. Jeffrey Cantor on behalf of Mr. Kyle, for limited purposes of arraignment, we waive formal reading and stand mute.
Okay, Mr. Collop, you have a right to remain silent. Anything you say orally or in writing will be used, can and will be used against you. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. If you can't afford an attorney, one will be appointed to represent you, and I've signed the request for court-appointed attorney. You have 2 days within the next 21 days. The first is your probable cause conference, and that is set for Monday, June 30th. And you can appear at that hearing via Zoom. Following that, you will have a preliminary exam where the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. And that is set to occur on July 7th of 2025. And that will be in person. As to bond.
Judge, no history, no holds. Mr. Collins works for Detroit Metropolitan. He does all their general maintenance, has held that position. That's in Detroit for 1 year, resides with family in Melvindale. I appreciate the serious nature of the charges, Judge. I would ask for the minimum bond.
Okay, yeah, the allegations or the charges are assault with intent to commit murder. And the allegations are that an individual, and I know that there's an allegation that Mr. Collop's not necessarily the shooter, but he was certainly, according to the allegations, engaged in the entire course of conduct here that led up to that. The allegations, this individual was shot in the chest. Had a through and through wound with a collapsed lung, amongst other injuries, and a low cash bond is not appropriate. He has a $250,000 cash or surety bond.
How much?
$250,000 cash or surety.
You're 10% on that?
No, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're not to have any contact with Javante, Beverly. Dominic Nino. Sol Perez. No contact with them of any kind. You can't go back to Big League Brews. You cannot go to any of these individuals' homes, work, or schooling. Cannot possess or have firearms or other dangerous weapons. You can't possess or have access to them. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. If you do post bond, you'll have a GPS tether while on bond.
Has pretrial services reviewed.
I will request a DSU report.
Thank you.
Your Honor.
Yes, sir. Anything you say can and will be used against you, sir. So I caution you to making any statements to me at all.
Okay, I got you. I was just, will I be able to get a personal bond?
I can't hear you. What's that?
Will I be able to get a personal bond today?
Absolutely not. So the allegation is someone was shot in the chest, sir.
I understand that.
It's a life offense. I'm not budging on that.
Thank you.
Yeah.
I have a family. I have a lot going on for myself.
Okay, we'll see you at your next court date, sir, next week. You'll be here in 1 week. This is 251791, the people of the state of Michigan versus Douglas William Waddy. Okay, can you raise your right hand? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Can you state your name for the record?
Detective Corporal Mark Johnston.
Have you read the type complaint that was filed with the court?
Yes, Your Honor.
Are the facts stated in the complaint true to the best of your knowledge and belief?
Yes, Your Honor.
You state the facts that support the issuance of the arrest warrant.
Yes, on June 17th, 2025, at approximately 12:59 a.m., officers were dispatched to 8280 Pine. Dispatch advised that the caller was 10 years old and stated someone was abusing his mother. Upon arrival, officers spoke with the victim, Stephanie Seiler, who stated the following. Her son is witness Joshua Reed, was staying the night at that location. He has been a close family friends. She has been close family friends with the victim, Carrie Taylor, who resides there with her boyfriend, Douglas Waddy. Carrie's son, Liam Taylor, is close with her son, Joshua. Joshua called her and stated she needed to come pick him up. Joshua was crying and said Douglas broke Liam's TV and hit Carrie. Joshua said Carrie's mouth was bleeding and she stayed on the phone with her son while she drove over there. When she got to the residence, the following occurred. She observed Joshua, Liam, and Carrie outside walking towards her vehicle. She told Joshua and Liam to sit inside her car, and she told Carrie that she needed to go inside and get Joshua's things. Carrie said Douglas would not let her into the house. Carrie tried to open the front door with her key, but believed Douglas was holding onto the doorknob, which prevented them from opening the door. They went to the back door, where she was unable to gain access to her home again. They then returned to the front door, where they were able to unlock it. Carrie yelled into the house, telling Douglas that Stephanie was coming in to get Joshua's belongings. Douglas walked towards Stephanie and stated, "Bitch, you're breaking into my house." Stephanie told Douglas that Carrie had let her in. Douglas then started calling Stephanie several profanities. Douglas grabbed a metal pole and started hitting her with it. She believes Douglas struck her with the pole approximately 10 times, and he struck her in the head several times during this assault with the pole. At some point, she was able to grab the pole away from him and strike him with the pole to prevent him from coming at her. Douglas then grabbed 2 shoes and placed each of them on his hands, put his hands inside of the shoes. Douglas then struck her with both of the shoes. He struck her once with the left shoe and once with the right shoe. Douglas then stated to her, "You are getting off my property, bitch." Douglas then grabbed the collar of her shirt and dragged her outside from the front porch. Douglas pulled her entire shirt off while he was pulling her outside. Douglas then punched her in the face with a closed fist, and she then pushed Douglas, which is when he fell into the porch railing, causing it to break. She also told officers at some point during this altercation, Douglas had choked her for approximately a minute with both of his hands when she was unable to breathe and got lightheaded. Officers observed Stephanie had red marks around her entire neck. She also had a swollen bump on her forehead and multiple red marks around her body. She declined any medical attention. Officers then spoke with the resident victim, Carrie Taylor, who stated she has been in a relationship with Douglas for 1 year and currently resides with him and her son, Liam Taylor. Douglas had punched her with a closed fist in the face and would not let her into the house. She declined to prosecute.
Wow. Did you sign the complaint before you sent it over to the court?
Yes, Your Honor.
Let the record indicate that I find probable cause to believe the accused committed the alleged offense and I'll therefore issue the warrant. Thoughts on bond?
Yes, Your Honor. Obviously, no contact with Ms. Seiler. I did speak with the other victim on the phone. She was adamant in not seeking prosecution, but during this time, we wish there to be no contact with Ms. Seiler at least. And sorry, I was just looking for his CCH really quick. He does have several convictions on here. I believe several of them were for domestic violence. In 2010, child abuse 4th degree, another domestic violence in 2016, another domestic violence in 2021 where he pled guilty, resisting assaulting police officers, pled guilty. And there's some other stuff on here for traffic related and retail thefts and stuff like that. So I'll leave the bond up to the court. Obviously, just no contact with any of the victims in this matter while the case is being resolved.
Okay. All right, thank you.
Thank you, Your Honor. I appreciate it.
All right. Who do we have in front of us here?
Douglas Waddy.
Okay, this is 251791, the state of Michigan versus Douglas William Waddy.
Good afternoon, Your Honor. Jeffrey Pianto on behalf of Mr. Waddy for limited purposes of arraignment. We'd wait for all reading. Stand be.
Okay, I'll enter a not guilty plea on your client's behalf. Mr. Waddy, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you, as Mr. Fanto was today, and I've signed a request for a court-appointed attorney to ensure you have counsel at your next hearing. You have 2 court dates within the next 21 days. The first is your probable cause conference, and that will be Monday, June 30th of 2025, and you can appear at that hearing via Zoom. Following that will be your preliminary exam, and your exam is set for July 7th of 2025, and that will be in person at the 23rd District Court. As to bond,
I know the court's aware of this history. He does have a hold out of Ionia and a hold out of Kent County. The Kent County is a child support matter.
yeah. The allegations in this case are alarming, to say the least. I note that the defendant has a criminal record dating back over 20 years, and he has several assaultive convictions. He also has a $25,000 warrant out of Ionia. Kent County, Southgate, and Melvindale also all have warrants on him, so he's a flight risk. Sir, You have a $75,000 cash or surety bond. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're not to have any contact with Stephanie Seiler or Carrie Taylor. You cannot go to where they live, work, or go to school. You cannot go back to the address of 8280 Pine Street in the city of Taylor. You're not allowed there. You can have one visit if you make bond with a police officer to obtain your personal possessions. You cannot have possess or have access to firearms or other dangerous weapons. You cannot consume alcohol or illegal drugs. If you do post bond, you will be subject to random testing. You also have a GPS tether.
Judge, could that be reviewed and can the file also be marked medical?
Yes, we'll mark it medical.
Thank you.
Are you requesting a DSU on him?
Please.
All right. All right, sir, we'll see you on the 30th for your next court date.
Yes, ma'am. All right, now we got Mr. Woods.
Okay. 251790, the state of Michigan versus Richard Anthony Woods. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Can you state your name for the record?
Detective Corporal Matthew Oliver.
Have you read the type complaint that was filed with the court?
Yes, Your Honor.
Are the facts stated in the complaint true to the best of your knowledge and belief?
Yes, Your Honor.
Can you state the facts that support the issuance of the arrest warrant?
Yes, Your Honor. On June 17th at approximately 12:33 in the afternoon, Taylor police officers were dispatched to 20336 Superior, which is Dearborn Midwest Company, on reports of an employee armed with a firearm inside the building. Due to the employee being in the building armed, the business began evacuating employees. Upon arrival, Corporal Schnell spoke with the manager, who was the caller, Mr. Willie Mitchell. Mr. Mitchell advised that earlier in the day, he had written up Mr. Richard Woods for conduct at work. Mr. Woods had left and returned to the building where other employees observed him armed with a handgun. As Corporal Schnell spoke with the manager, Mr. Mitchell, officers began surrounding the building and attempting to locate Mr. Woods. After a few short minutes, Mr. Woods was observed by Corporal Schnell exiting the north side of the building. Armed with his patrol rifle, Corporal Schnell approached Mr. Woods, giving him loud verbal commands to put his hands up. Mr. Woods did follow those commands, and Corporal Schnell was able to take Mr. Woods into custody. While conducting a search of his person, he located a loaded .357 Magnum handgun in his front right pocket, along with a large amount of loose shell live rounds. Mr. Woods was secured in a patrol vehicle and taken to the Taylor Police Department without incident. Mr. Woods is not a licensed CPL holder. While speaking with other employees, or Mr. Mitchell believes that Mr. Woods is having mental health issues recently, and that he brought the firearm into work because of that.
And there were multiple employees in the building?
Yes, Your Honor. I don't know the exact number. He was observed by 3 employees in a lunch area to be armed.
And the firearm was loaded?
Yes, Your Honor.
With extra ammunition in his pocket?
Yes, Your Honor.
And this was the day of a write-up?
He was written up earlier in the day. I don't know the specific context of the write-up, but.
What are your thoughts on bond? Well, let me ask you this first. Did you sign the complaint?
Yes, Your Honor.
Let the record indicate I find probable cause to believe the accused committed the alleged offense, and I'll therefore issue the warrant. What are your thoughts on bond on this case?
Speaking to what actually happened, we can, assume what was going to happen in the future. Mr. Woods has no criminal history. He is in his 60s. But after speaking with his manager, Mr. Mitchell, who now terminated him, he said in the last approximate year, there has been a drastic change in Mr. Woods' mental state. And I actually was contacted by one of his family members, his sister, who did corroborate that he has had a drastic change in mental state, accusing individuals of, watching him, racism, videotaping him. So as to bond, I would just say no contact with work, no, maybe a GPS monitor just to, make sure he does not go back to that location.
Okay. Okay, thank you, officer.
Thank you, Your Honor.
Mr. Woods?
Hang on 1 second, Your Honor. We got to open up the. Mr. Woods, come up here. The judge.
All right. This is 251790, the People versus Richard Anthony Woods. Mr. Woods, can you tell me your name, please?
Richard Anthony Woods.
Okay, Mr. Woods, you're charged here with one count of carrying a concealed weapon. The allegation is on June 17th of 2025 at the property of 20336 Superior in the city of Taylor. You did carry a dangerous weapon, to wit a revolver, concealed on or about your person, contrary to MCL 750227. That is a felony punishable by up to 5 years in jail and or $2,500 and mandatory forfeiture of the weapon. Mr. Woods, do you understand you have a right to an attorney, and if you could not afford one, I would appoint one?
I understand my rights as an attorney, and I understand the rights that you said, but I understand what you said as an attorney.
Okay, well, let me say this before you say anything else, okay? Mr. Woods, but you have to, listen to me first. Mr. Woods, Mr. Woods, Mr. Woods, I need you to understand something before you say anything to me. Please, I'm being very patient. Mr. Woods, you have a right to remain, okay, I'm gonna mute him. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have the right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. And if you can't afford an attorney, one will be appointed to represent you. And I am going to sign a form for a court-appointed attorney to be appointed on your case. And you can make your decision later on. But I do think it's best for today's date that we at least have someone appointed for your next 2 court hearings. You have 2 dates within the next 21 days. The first is your probable cause conference, and that is set to occur on June 30th of 2025. And you can appear at that via Zoom. Following that, you have a preliminary exam. On that exam date, the prosecutor will have to show that a crime was committed and probable cause exists to charge you with that crime. And that will be in person at the 23rd District Court on July 7th of 2025, sir. Now, you have a right to meet with an attorney today if you wanted to. And it's my understanding, Mr. Woods, that you did not want to meet with a lawyer.
Well, I really didn't think I need one because Rankins USA has given me my CCW. And they have confirmed that.
Okay, well, that's not what I have in front of me, sir. Do you want to talk to Mr. Fanto?
Yeah, I'll talk to him.
Okay. I'm gonna get the file to Mr. Fanto and we'll get you in a room so you can talk to him.
Excuse me?
Taylor PD will get you, Mr. Fanto's going to,
Go back to Polycom.
yeah, go back to Polycom with Mr. Fanto and Miss Isaac. I see your comments. I understand, and Mr. Fanto, just so you're aware, there is a family member that's in Zoom and she's made some comments regarding the mental health of the defendant here, so.
That was false.
Okay. Oh, we'll get 1 second. You can talk to Mr. Fanto, okay?
The message came across that screen.
All right, I'll meet you in
That's
Polycom.
my niece.
Okay, thank
Okay, over at the jail, we're ready. Am I unmuted yet? We're ready for Mr. Woods when you are. Oh, you saw my note on here.
Your Honor, I just had to fight him in the cell.
You just had what?
I had to fight him into the cell. He refused to get into the cell. So we had to fight him.
Okay,
Started throwing punches, the whole nine.
okay. Do you guys want a few minutes to get everything together over there so I can just continue this? Or is he not?
Give us a second. I don't know how cooperative he's gonna be, but
Okay. All right, well, you take a breath.
thank you.
You guys take a breath over there and stay safe and just, we'll give it a few minutes. If you even want to log out for 5 minutes and then come back in when you guys are collected over there.
Sounds good.
All right, thank you.
Thank you. Can you hear me?
Yes, I can hear you. All right, we're back on record with Richard Anthony Woods. So I've signed the request for a court-appointed attorney. Mr. Woods, you have 2 court dates within the next 21 days. The first is your probable cause conference. That'll be June 30th. And you can appear at that via Zoom. Following that, you'll have a preliminary exam where the prosecutor has to show that a crime was committed and probable cause exists to charge you with that crime. And that will be on July 7th of 2025. Mr. Fanto, anything?
Good afternoon, Your Honor. Jeffrey Fanto on behalf of Mr. Woods. And I'm sure, although I didn't bring it up with him, I'm sure it would be on his, over his objection, but I would ask the court refer this matter for competency in all aspects. Obviously, mark the file medical.
I'm marking the file medical mental. I'm referring for competency. And the problem is, this is a 5-year felony, but the allegations, which are just allegations, but there's certainly allegations that I need to take into consideration when setting bond. And the allegations are that Mr. Woods was written up at work and went up to work with a revolver in his pocket that was fully loaded, and he had multiple loose ammunition in his pocket. And I mean, this, you know, these allegations are particularly concerning. This could have been a tragedy had one thing gone wrong. And I do think that that is something that, an allegation that needs to be taken into consideration while determining bond on a case, even though the only charge in the complaint and warrant is a 5-year felony for carrying a concealed weapon. And there were also some allegations of conduct that just occurred over at the jail that's also incredibly concerning to this court. So I'm setting a $25,000 cash or surety bond with a GPS tether. Sir, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot have any contact with 20336 Superior. And what is the name of the business there? Dearborn Midwest Company. You cannot have any contact with Dearborn Midwest, I'm sorry, company. You can't go there. You cannot have any contact with any employees of that location or the owner or employer. Sir, you cannot possess or have access to firearms or other dangerous weapons. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. You will be fashioned with a GPS tether. You will have a curfew from 8 a.m. to 8 p.m. if you are able to make bond. And those are the conditions of your bond, sir. Do you have any other requests, Mr. Fanto?
No, Your Honor.
Okay, Mr. Woods, we'll see you back next week, but I am putting in a competency referral, but we'll have an attorney here for you at that time. Okay?
Thank you.
Thank
What happened to the 17th? I was supposed to go to court.
The 30th and March 30, or I'm sorry, June 30th. So that's not this Monday coming up, but the Monday after that, and then July 7th. Those are your two court dates, and I'll see you on both of those dates.
Thank you, Your Honor.
Thank you.
Have a good day.
You too.
Thank you, officer.
Sorry.
Well, ladies and gentlemen, that was an interesting set of cases, wasn't it? I don't really know what to say about all of them. That last one, that was one fatal shot away from being national news, and Lord have mercy, it would have been God knows what. Thankfully, it didn't end up that way. Thankfully, it is what it is. It's been an interesting Saturday watching court with everybody. It's been an amazing chat. Thank you very much for coming and hanging out. I am your Lone Wolf Usul. I am your curator for these here videos on the channel. I am the host for this here weekend case review shindig that we do every Saturday. We also get together every weeknight about 8 p.m. Central Time. That's 9 p.m. Eastern, where we do pretty much the same thing for the daily dockets of the day. We just kind of watch a couple of hours of dockets and talk about it and chat. We're not necessarily live. We do that as a premiere every night, but hey, chat's great. It's great to hang out. I do appreciate everybody who commented today. That helps out a lot. I love when y'all comment on the videos, and I post them up there so we can maybe take these and make these into other videos later. The very first case we looked at is probably going to end up as a compilation very soon. I have a serious feeling about that. Ladies and gentlemen, it's been wonderful. It's been fun. It's been a Saturday. Let's do it again sometime. How about I see y'all Monday night? I am your Lone Wolf Usul. I am your host, and I will see you next time. I'm out.